Okay, Ms. Edwards, do you want to come forward to your Katrisa Edwards?
Yes.
This is file 24-21766-FH and 25-22100-FH. People versus Kateresa Pearl Edwards. We are here today for a hearing on an order to show cause regarding an alleged probation violation in each of those files. And we are proceeding today in person. Ms. You are Kateresa Pearl Edwards, correct?
Yes, I am.
Ms. Edwards, you've received copies of the request and summons for probation violation?
Yes, I have for both of them, for both of them cases.
Okay. So those allege that you violated your probation by failing to report to your probation officer on July 7 and July 21st of 2026. Also by failing to complete drug testing on July 8 and July 9, 2026, and also by failing to attend substance abuse treatment in June as you were instructed. In file 24-21766-FH, you were convicted of one count of abandoning or cruelty to an animal, and the maximum penalty for that offense is up to 1 year in jail and or a $2,000 fine. In file 25-22100-FH, you were convicted of one count of possession of cocaine, and the maximum possible penalty for that offense is up to 4 years in prison and or a $25,000 fine. You do have the right to be represented by an attorney today. If you're unable to afford an attorney, you can tell me that. I'll appoint one for you from the public defender's office. Do you understand that?
Yes.
Would you like to be represented by an attorney?
Yes.
You have the ability to pay for your own attorney. All right, I will appoint the public defender's office to represent you. If you will step out to the hallway, there's an iPad on a stand just to your left as you walk out the door.
Right.
And I'll put you in a breakout session with Ms. Underwood from the public defender's office. You can speak to her.
All right, thank you.
Thank you, Your Honor.
Ms. Underwood. Sergio, could you step out and help her to the camera and the microphone? Read who's here first. Who's the first? Okay, we have Ms. Edwards and Ms. Underwood back from the breakout session now. Ms. Underwood, do you know how Ms. Edwards would like to proceed today?
I believe Ms. Edwards would like to plead guilty to the violation, Your Honor.
All right. Ms. Edwards, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do.
And Ms. Edwards, do you understand that you have a right to contest the violation of probation charges and to have trials on them?
Yes.
You understand that throughout that trial, you would be presumed innocent until your guilt is proven by a preponderance of evidence.
Yes.
You would also have the right to have all of the witnesses against you appear at your trial. You or your lawyer, if you had to, you or your lawyer could ask those witnesses questions while they are under oath. And you also have the right to have me order any witnesses you have for your defense to appear at your trial. You understand all of that?
Yes.
You are not required to testify at your trial. And nobody can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes.
On the other hand, you also have the right to testify if you wanted to testify. Do you understand that as well? How do you plead to these charges that you violated your probation?
I plead guilty.
You understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've explained to you?
Yes.
Has anything been promised to get you to plead guilty?
No.
Has anyone threatened you in any way in order to get you to plead guilty?
No.
If I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats, promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes, it is.
So you were placed on probation back in May of 2025, is that correct?
Yes.
And one of the conditions of your probation was that you report to your probation officer as often as she instructed you, is that correct?
Yes.
And did she instruct you to report on July 7th and July 21st?
Yes.
Did you report on either of those days?
No, I didn't.
Another condition of your probation was that you comply with drug testing, is that correct?
Yes.
And were you required to test on July 8th and July 9th of 2026?
Yes.
And did you test on those days?
No, I did not.
Another condition of your probation was that you complete substance abuse treatment when your probation officer referred you to substance abuse treatment, is that right?
Yes.
And were you referred for substance abuse treatment in June?
Yes, I believe it was June and the end of June, maybe beginning of July.
And
Yeah.
did you participate in that treatment?
No, I just did the rest of my time in jail and then
Okay. I will accept the plea. The pleas then they have been given understandably, voluntarily, and accurately. Ms. Edwards has had full knowledge of her rights and she's had competent counsel. I will refer this matter to the probation department for an update of your pre-sentence investigation and set sentencing for August 20.
I'm sorry, what
First.
is that date again?
August 21st at 8:15 a.m. So your probation officer will be in touch with you to do an interview and update your pre-sentence investigation. So please be truthful about what's happened and about your background.
Okay, so do I just report regularly like I'm supposed to until the sentencing?
Ms. Walsh?
You'll need to give me a call, Miss Edwards.
Okay, I sure will.
Okay, so give Ms. Walsh a call.
Okay, thank you.
So you're all set for today.
Thank you.
Could you? Ms. Underwood, you need to speak to Allison Scholes.
Yes, please.
Ms. Scholes, are you there? Ms. Scholes,
Yes,
can you hear me?
Can you hear me?
Yes, I'm going to put you in a breakout session with Ms. Underwood.
Okay. Mm.
Said yes. Mr. Fry, do you need to speak to Mr. Pringle before you start?
Is he here?
Yeah.
Okay, yes. I didn't realize he was here.
Yep, he's in the back.
It looked back there, okay. Is he on your side?
Yes.
Okay.
Okay, this is file 23-21524-FH People versus Allison K. Scholes. We are here today for a hearing on a probation violation, and we are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Ron Underwood for Ms. Scholes this morning, Your Honor. Thank you.
And Ms., you are Allison Scholes.
Yes.
Ms. Underwood, where do we stand with Ms. Scholes' situation?
Your Honor, Ms. Scholes has $400 that she's going to money order to Mr. McCarron. She will give him to where she needs to. Once she finds out from Mr. McCarron, she will send him a tracking number. She can do that today, Your Honor. That would be $100 a week since the last hearing, Your Honor. And she's also picked up a second job that she starts on Monday.
Okay, so $400 is getting paid today?
Correct.
But there haven't been any payments since the last hearing?
That's correct, Your Honor. This is catching up.
All right, I'll adjourn this to August 19th. I think at this point, we have to, I have to have pretrials a little more frequently to make sure things are happening in the way that I'm told that they're going to happen, which doesn't appear to be the case to this point. So I'm gonna have to make sure that that payment gets made, or we're gonna have to set this for a trial. This has been ongoing since February, and she said that there's been plenty of opportunity to get the situation corrected. So if it's not corrected at the next pretrial, I'm going to set it for a hearing.
Thank you, Your Honor.
Thank you, Your Honor.
All right, Ms. Scholes, you can go ahead and log out then
Okay, what time on August 19th?
at 8:15.
8:15. Okay, thank you.
All right, Ms. Underwood, do you need to speak to Daniel Bowen?
Is he in the courtroom, Your Honor?
Yes.
I will be out in the hall to talk to him in just a second.
Okay, Mr. Bowen, if you'll step out to the hallway, Ms. Underwood will meet you out there. This is file 24-21987-FH People versus Daniel Don Bowen. We are here today for a pretrial conference. We are proceeding today both in person and by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Bowen this morning, Your Honor.
Sir, you are Daniel Don Bowen?
Yes, Your Honor.
All right, Ms. Underwood, where do we stand with Mr. Bowen's case?
I believe we are ready to resolve this matter this morning, Your Honor, with a plea, Your Honor. And I do have a signed copy of Mr. Bowen's advice of rights that I would like to present to the court. And then, Your Honor, I believe it would probably be more efficient for Ms. Brenner to state the terms of the plea bargain, Your Honor.
Okay, I'm just scrolling back to see if we even ever outlined it, Rhonda. Hold on one second, because
I'm sorry.
we started at, can you guys hear me okay?
Yeah.
Okay, we started at,
Period.
okay. Hold on one second, let me pull, I had a different case up in front of me. Hmm. Okay, so he's charged with one count. So he's going to be pleading guilty to count one, failure to pay child support. Judge, we're going to ask that you put him on a delay of sentence for 11 months. He's going to need to continue making his payments. And let me see if he has a current monthly obligation or if we need a stipulated amount, but he doesn't have a current obligation. So then what amount can he agree to paying consistently over the next 11 months? A minimum. Rhonda, can he stipulate to a minimum amount? Can he stipulate to a minimum amount that he will pay monthly during the delay?
Okay. I'm sorry, what is that amount?
I want him to tell us an amount that he will pay monthly during the delay, a minimum amount. He can pay more than that, but I don't want him to set it higher than what he feels confident he can do every month during the delay.
600 a month.
Okay, so Your Honor, we're asking the court to put him on a delay for 11 months. He'll pay $600 a month minimum. If he's able to reduce his arrearages down to 30,000 or less, then we would reduce the charge down to an attempted failure to pay child support. And if he pays the balance in full, then we would reduce the charge down to a misdemeanor disorderly person. Right now, he is at just over 43,000.
All right, Ms. Underwood, that all agreeable with Mr. Bowman?
Yes, Your Honor.
Mr. Bowen, will you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
You are Daniel Don Bowen.
Yes, Your Honor.
Mr. Bowen, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, failing to pay child support?
Yes, Your Honor.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $2,000 fine?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record this morning. Is that correct, Ms. Brenner?
That is correct, Your Honor.
Ms. Underwood?
It is.
Is that also your understanding, Mr. Bowen?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Bowen, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about February 1st, 2018 through February 29th, 2020 in the city of Adrian, county of Lenawee, state of Michigan, that you did commit the offense of failing to pay child support?
Yes, Your Honor.
If you want to plead guilty, you would need to say guilty.
Oh, guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that close the board on the record today, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Bowen to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Bowen, other than as we've talked about on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be? If your plea is accepted and you engage in misconduct, the court is not bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
Ms. Underwood, do you want to establish the factual basis?
Your Honor, if I could prevail on Ms. Brunner to do that, the file's in that.
Sure.
So
That's fine. Mr. Bowen, were you ordered to pay child support in the city of Adrian, county of Lenawee, state of Michigan?
Yes.
And that was to Miss Elliott for your child?
Yes.
And between the dates of February 1st, 2018 and February 29th of 2020, did you fail to pay the amount that you were ordered to pay in the amount or at the time that the order told you to pay that?
Yes, Your Honor. Yes, ma'am.
People are satisfied, Your Honor. Thank you.
All right. Has the court complied with MCR 6.302 B, C, and D, Ms. Brenner?
Yes, Your Honor.
Ms. Underwood?
it has.
All right. I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Bowen has had full knowledge of his rights, and he has had competent counsel. The court has not made any agreement regarding possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation. We will set sentencing out to July 23rd, 2027 at 8:15 a.m.
And Your Honor, did you want a date before that? Usually we come back and then we put them on the delay, or did you want to just set them out that far?
Is there anything we're going to do at the next hearing other than put them on a delay?
No, Your Honor.
Okay, I don't really see the need to do that then. I'll just set it out.
Okay.
And if there's an issue between now and then.
That's fine.
The, state can contact our office to accelerate the sentencing if that should need to happen.
Okay. Thank you, Judge.
Judge, this would not go to Darren?
No, there isn't any supervision. He's just supposed to make payments. If he doesn't make payments, Ms. Brenner can contact the office and we can move up the sentencing.
So you want a PSI done, correct?
I don't need one done immediately. The sentencing date isn't until July 23rd.
So Your Honor, do we want to set a review date? Maybe if we set a review date for June, we can come back in June and see what PSI they need to prepare at that time, if he's earned a reduction or not, just to check back in.
I think usually Darren takes these cases to supervise to make sure he's making the payments.
Yeah, that's how we
Yeah.
typically do it.
But I think the state can monitor that and we can move the sentencing up if it needs to happen. I don't think that using Darren's resources to monitor that is necessary.
Yeah, that's fine, Judge. Like I said, can we just set a review date so we make sure that it's on probation's radar and they can prepare that report? Next year, we'll kind of do a reminder date, a review date.
I can set it for a status conference on June 9th at 8:15 a.m. That's a Wednesday morning.
Okay, that'll be great. Will that be enough time to prepare the report then, Ms. Walsh, from June 9th to July 23rd?
Yes.
Okay, all right. Thank you, Judge.
Thank you, Your Honor.
All right, I think we're all set with this case then.
Thank you.
Yeah, we do it that way in a lot of my counties, Judge, where we don't do a PSI and have probation use their resources, but we'll just come back for a review at the end.
I think that's a little more efficient.
Yeah.
Mr. Murphy, I have Mr. Smith here in the courtroom. Do you need to speak to him?
If I could just briefly, if you can go in the hallway, that works.
Mr. Smith, if you'll step outside, there's an iPad on a stand just to your left.
I'll click something.
Mr. All right, Ms. Irwin, do you need to speak to Brian Ransom? You're muted.
Hello?
Yeah, good morning, Mr.
Yes,
Ransom.
just briefly, Your Honor.
Hello?
Mr. Rance, I'm going to put you in a breakout session with Ms. Underwood. Yeah, you can come forward, sir. This is file 26-22674-FH People versus Kenneth Gene Smith. We are here today for a pretrial conference. In this case, we're proceeding today by video conference. First, going to have the attorneys place their appearances on the record, beginning with Mr. McCready.
Morning, Your Honor. Dave McCready for the people.
Matthew Murphy, appearing on behalf of Mr. Smith.
And Mr. Murphy, where do we stand with Mr. Smith's case today?
Your Honor, we had a preliminary examination in this matter. I was requesting the transcript from the preliminary examination, so I'd ask for this to be set out. Now, I was looking at my file. It looks like we had sent it over on June 17th. By looking at the register of action I found online, I couldn't find a record on there of the court receiving it. So I'm just gonna, I mean, obviously, all we're gonna do today is set it out. I guess I'd ask for at least 60 days. Or I guess, if it was received on June 17th, I guess I'm not sure what the time frame on that would be. I just was gonna try to reach out to the, see if the court did actually receive it or not. I don't see why they wouldn't have. I can't see the register of action for the district court.
Yeah, I don't see anything in the circuit court file indicating that the transcript has been ordered. So you sent your request to the district court or the circuit court?
Well, all I see is that it said it was sent over in our runner's file. Here, let me see if I can pull up the order itself, because the notation doesn't say where it was delivered to. I mean, it looks like it was only had the district court file number on it, so I assume it was sent down to district court.
All right.
So again, if we could say on that was June 17th, if we could do, just 60 days, I'll track that down. Obviously today, if there's any issues or anything, that'll have that cured and have the request. Again, if there's any issue with that, I'll fix that. But if that's okay with the prosecution, I'll just ask for an adjournment of probably 60 days.
You were muted, Mr. McCready.
Yeah, sorry, no objection.
Okay. Let's adjourn this then to October 7th at 8:15 a.m.
Yes, sir. In my office to do a stipulation order for October 7th at 8:15.
Okay. Anything else we need to address with Mr. Smith's case?
Not from the people.
Nothing from the defense, Your Honor. Thank you.
All right, Mr. Smith, your next date's October 7th at 8:15 a.m.
Thank you, Your Honor.
Thank you.
Thank you, Mr. Smith. Again, just call if you have any questions or issues, okay?
All right, sounds good. Thank you.
Okay, Ms. Underwood, are you ready to proceed with Mr. Ransom?
Yes, Your Honor, thank you.
This is file 26-22522-FH People versus Brian Ashley Ransom. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. Can I have the attorneys place their appearances on the record?
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Ransom this morning, Your Honor. Thank you.
And sir, you are Brian Ashley Ransom?
Yes, sir.
Ms. Underwood, where do we stand with Mr. Ransom's case?
Your Honor, Mr. Ransom is providing a good payment history. I've discussed this matter with Ms. Brenner. I believe it would be appropriate, and I don't believe she would have any objection to a 60-day adjournment in this matter, Your Honor. And I would be happy to do the stipulation in order with her permission.
Well, he was making good payment progress, but he hasn't paid anything since the end of June. So I don't know what happened there.
I fractured my hand and I haven't been able to work.
Okay, so
I'm going to double up.
Back this week.
I will be able to double
up
my payment this month for last month and this month. Because I paid June, I just did not pay July because of my hand.
Okay. All right, Your Honor. Then with that explanation, I'm okay with giving him more time to get back on track.
Okay. I will adjourn this then to October 7th at 8:15 a.m.
Thank you, Your Honor.
Thank you.
All right, so Mr. Ransom, United States, October 7th at 8:15. You will log in using all the same Zoom information you used today.
Yes, sir.
And I will be happy to do that stip in order, as I said, Your Honor.
All right, thank you. Mr. Ransom, you can go ahead and log out.
Thank you, sir.
You fall for Trevor. Okay, Mr. Dagamrangosi, you have Mr. Dorsey.
Yes.
This is file 26-22597-FH People versus Dante Devin Dorsey. We are here today for a pretrial conference. No, I'm sorry. We're here today for a show cause hearing. And also for a pretrial conference. First, we have the attorneys place their appearances on the record.
Allison Arnold for the People.
Your Honor, good morning. Michael Dagamrangosi for Mr. Dorsey.
Is there another number that I can call? Thank you.
All right, Mr. Dagamrangosi, where do we stand with Mr. Dorsey's case?
Your Honor, regarding the underlying case, we do have a resolution with the people. The issue is there will be a plea entered. However, it's somewhat of a complex factual scenario. And so I spoke with Ms. Arnold this morning, and we believe that the best course of action would actually be to set this for a plea hearing, maybe on a different day. tomorrow or Friday or whatever works for the court. But I do want to just kind of correspond with her as well as Mr. Dorsey on making sure that the plea is legitimate and goes through.
All right, Ms. Arnold?
We agree, Judge. And Judge, I think we could do it tomorrow or Friday if that works for the court.
Sure that it does, but Francis, do we have anything available tomorrow or Friday?
I can't do Friday afternoon because I have a repair person coming to my house, but I could do tomorrow or anytime Friday morning, most of the day.
Judge, you could do tomorrow at 1:30 before the evidentiary hearing we have.
All right, I'll set it then for tomorrow, August 6th at 1:30 p.m. I also have a note in the file that indicates there have been some issues with Mr. Dorsey's drug testing situation. Mr. Coast, is there anything you want to address with respect to that issue?
I do, Judge. I actually did a swab on Mr. Dorsey on 7/28. That swab was actually sent out to Forensic Fluids, and it was lab verified positive for cocaine. This morning, I actually had Mr. Dorsey do a urine test for myself, and that was positive for both cocaine and also meth.
All right, if that is the case, the court would consider at this point modifying Mr. Dorsey's bond. Is there anything, Mr. Dagger-Mangosi, you would like to say about that?
Your Honor, what I'll say to the court is my understanding is that Mr. Dorsey has been testing clean for, he indicates to me, about 14 tests straight, as well as the fact that we have turned this case into a plea hearing. I would ask the court to take that into consideration when addressing bond or modification of bond. If we want to maybe defer proceedings until tomorrow, that would make sense too. But I do recognize that what Mr. Coase says, but I would ask the court to maybe just push this out until tomorrow to deal with it. And yeah, and Mr. Dorsey will retest with Mr. Coase tomorrow as well if needed.
I'll take the same test. One last test.
Well, when's the last time he used? Because if he tested dirty today, how's he going to use clean tomorrow?
Well, Judge, we can talk with Mr. Coast as to the validity of the test. Again, we're not challenging the test right now, but I can speak with him on the test results as well.
Ms. Arnold?
Judge, the plea would involve a minimum prison sentence of 6.5 years, so we're not really concerned about remand for the bond violation. Mr. Dorsey has appeared in court, so the issue might be sort of moot if there's a plea.
Well, I think my concern here is that it is more than just these recent instances. Mr. Dorsey's case was bound over to the circuit court on March 12th of this year. On March 26th of this year, the court received a complaint after Mr. Dorsey was arrested, allegedly in possession of 14 grams of crack cocaine. And now, having released Mr. Dorsey, he has a couple of positive tests for continued drug use. So I acknowledge that the plea hearing is only being set over until tomorrow. But I'm faced with apparent continued criminal activity by Mr. Dorsey. He was already on a $25,000 bond that he's posted, which is how he got out after the arrest. And so at this point, I think the bond needs to be increased. And so at this point, I ask that Mr. Dorsey be taken into custody, and I'm going to set a new bond in the amount of $50,000 cash or surety. And we will proceed tomorrow at 1:30 p.m.
Thanks, Judge.
Deputy Frostville will take Mr. Dorsey into custody and reset his bond. Is there anyone you need to speak to, Mr. Boss?
Yes, I do, Your Honor. Is Mr. Okay. I don't see Mr. Bayonetto. Your Honor, I'm going to ask that we hold off on Mr. Boss, or maybe even schedule it for tomorrow for a plea hearing.
I can't schedule everything for tomorrow. This is the Wednesday docket call, and people know what happens on Wednesdays.
Okay.
I'm filling in for Mr. Bayonetto this morning. He had an emergency and couldn't make it in.
Okay. If I could speak to Mr. McCready then.
Mr. Goldstein, are you ready to proceed with Mr. Banks?
Yes, Your Honor.
This is file 26-22636-FH People versus Christopher Adele Banks. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. And I apologize, I just realized that I only had one prosecutor and he just went to a breakout session with another attorney, Mr. Goldstein, so we're gonna have to wait till he's back.
No problem, Your Honor. Thank you.
Sir Dagamar goes in to have Brett Donnelly logged in on Zoom. Are you gonna need to talk to him? No. Okay. I don't have a prosecutor at the moment, so as soon as we have one, we'll get those started. Ms. Underwood, are we ready to proceed with Mr. Boss?
If I could speak to Mr. Boss for just a second, Your Honor.
Okay, we can go back to file 26-22630-FH People versus Christopher Banks. Again, we're here today for a pretrial conference and proceeding by video conference. Can I have the attorneys place their appearance on the record? Mr. McCready, are you covering this one?
Dave McCready for the people.
Mr. Goldstein. Mr. Goldstein, you want to place your appearance on the record?
Sorry, Your Honor. David I. Goldstein, appearing on behalf of the defendant.
Okay, and where do we stand with Mr. Oh, well, sorry, sir, you are Christopher Banks, correct?
Yes.
All right, Mr. Goldstein, where do we stand with Mr. Banks' case?
Your Honor, this matter has been adjourned several times because we've been told both by the Adrian PD and the prosecutor's office that they are looking into some additional charges against Mr. Banks. As of this morning, those charges have still not been brought. So I'm at the point where I would say, let's either make a deal on this case or let's set it for trial. Because I don't know if there's going to be other charges or not.
Okay. Mr. McCready, anything from the people's side?
Yeah, I'm just looking up. So it looks like we asked for further investigation on there's a retail fraud first warrant being requested by Madison Township, and we asked for a follow-up investigation on July 13th, and I don't have any further information after that. I'm filling in for Ms. McClure on this one, so that's the extent of the information I can provide at this point.
Okay, Mr. Goldstein, then do you want me to just set it for a trial date?
We may as well, Your Honor, and if things happen in the, I assume it's going to be a while out. So if things happen in the meantime, we can always come back.
Okay, and how long do you think you'll need for a trial here?
2 days, Your Honor.
I'll have to rely on Mr. Goldstein for that, Your Honor.
Okay. Ms. Clark, could we have a 2-day jury trial date, please?
Would you like that as a backup, Judge?
That's
Mr.
fine.
Goldstein? Okay.
Yeah, that's fine, because there's a good likelihood that this matter can be resolved, but let's go ahead and set it for now. Till we see what-
Thursday, October 15th at 9 a.m. and Friday, October 16th at 9 a.m.
I already have a jury trial scheduled in front of Judge Ansel that day.
Wednesday, October 21st at 10:30 and Thursday, October 22nd at 9.
Yeah, that should work.
I'm just looking at TV schedule. Yeah, looks like she's here. You said the 21st and 22nd of October?
That's correct.
Yeah, okay, that sounds good.
Okay, so 21st and 22nd of October, let's do a final pretrial on October 14th at 8:15.
That works.
The court will send out a scheduling order. Mr. Banks, your next date is the final pretrial on October 14th at 8:15 a.m. You can attend that by Zoom with all the same Zoom information you used to log in today.
Okay. Thank you.
All right, you're all set. You can go ahead and log out.
All right.
Thank you, Your Honor.
Mr. Dagger, you ready to proceed with Mr. Don? Yes, ma'am. This is file 26-22666-MH, People of the State of Michigan versus Brett James Donnelly. Oh, I should bring Mr. Donnelly into the Zoom session. Okay, this is file 26-22666-FH People versus Brett James Donnelly. We are here today for a pretrial conference, and we are proceeding today by video conference. First, going to have the attorneys place their appearances on the record.
Dick McCready for the people, standing in for Alex Bayonetto.
Michael Dagger-Margosian for Mr. Donnelly.
And sir, you are Brett James Donnelly.
Yes, sir.
Mr. Dagger-Margosian, where do we stand with Mr. Donnelly's case?
Your Honor, the court should have a signed vice rights and signed plea agreement. There will be, Mr. Donnelly will be pleading guilty to count 1. The habitual offender status will be dismissed, and we can enter that plea now.
All right, Mr. McCready, is that a complete and accurate statement of the plea agreement?
Yes, sir.
Yeah, I've got a plea guilty to count 1 as charged, dismissal of habitual offender supplement, and no other conditions as agreed to.
Mr. Donnelly, will you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Brett James Donnelly?
Yes, sir.
Mr. Donnelly, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, operating while intoxicated, 3rd offense?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is a fine of $500 to $5,000 and either 1 to 5 years incarceration or probation with 30 days to 1 year in jail, at least 48 hours to be served consecutively, and 60 to 180 days of community service?
Yes, sir.
Are you satisfied with Mr. Dagger-Margosian and the advice that he's given you?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed possible sentence with the court. Is that correct, Mr. McCready?
Yes.
Mr. Dagger-Margosian?
Correct.
Is that also your understanding, Mr. Donnelly?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Donnelly, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights I've explained to you?
No, sir.
Do you understand that you're giving them up?
Yes, I do.
How do you wish to plead to the charge that on or about August 1st, 2025, in Lenawee County, Michigan, that you did commit the offense of operating while intoxicated, 3rd offense?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Donnelly to plead guilty today?
I'm not.
No. Mr. Donnelly, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
Is it your own choice to plead guilty?
Yes, sir.
Mr. Dagger-Margosi, do you want to establish a factual basis?
Mr. Donnelly, on August 1st of 2025, were you in the county of Lenawee, state of Michigan?
Yes, I was.
All right, and on that day, were you operating a motorcycle?
Yes, I was.
And this was on Posey Lake Highway and Cadmus Road?
Yes.
And at that time, do you agree that you had a blood alcohol content of 0.08 grams or more?
Yes, sir.
And for plea purposes, do you agree that you have 2 prior OWI convictions, one from February 6, 2024, from the Fourth Circuit Court in Jackson,
Yes.
as well as one from October 19th, 2018, here in District Court, Lenawee?
Yes.
Okay, I'm satisfied.
People aren't satisfied.
Has the court complied with MCR 6.302 B, C, and D? Mr. McCready?
Yes.
Yes, Judge.
Thank you. I will accept that it's been given understandably, voluntarily, and accurately. Mr. Donnelly's had full knowledge of his rights. He's had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for September 11th at 8:15 a.m. Mr. Donnelly, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Yes, sir.
We just need Mr. Donnelly to go to our office today to pick up his paperwork.
Okay, so Mr. Donnelly, you need to come to the probate office on the 3rd floor of the courthouse today and pick up your paperwork.
Okay.
All right, otherwise you are all set and you can go ahead and log out.
All right. Thank you.
Thank you. All right, Ms. Underwood, are you ready to proceed with Mr. Boss?
I guess so, Your Honor. Thank you.
This is file 25-22189-H and 26-22686-FH, People versus Trevor John Boss. We are here today for pretrial conferences in both of those cases. And we are proceeding today by video conference. There's also pending contempt of court in the 25-22189-FH case. First, can I have the attorneys place their appearance on the record, beginning with Ms. Brenner in the 25 case.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People on that matter.
And Mr. McCready for the 26 case.
Dave McCready for the People, standing in for Alexander Bandetto.
Rhonda Underwood for Mr. Boss on both cases, Your Honor. Thank you.
All right, and where do we stand with Mr. Boss's cases today, Ms. Underwood?
I thought we were going to resolve them today, Your Honor, but Mr. Boss wants a little time to consider his options. I would ask if we could set this over for maybe next week, if that's possible. I'm guessing you're probably pretty crowded.
I'm off on that day. Can we go 2 weeks?
Yeah, I'm actually not here next week, but I can set it for August 19th at 8:15.
Thank you.
Thank you, Your Honor.
Ms. Underwood, would you do that stipulation in order, please?
I would be happy to do both stipulations and orders.
Thank you.
Okay, and we still need prints on the 25 case, so we'll, I guess, contact the jail and see if they can arrange to have his prints done at the jail.
Thank you.
Okay, Mr. Boss, you can let the officer with you know that you're done with court for today.
All right, thank you, Your Honor.
Hold on.
Ms. Underwood, you need to speak to Mr. Rowell.
Yes, I do, Your Honor. Is he in custody?
No, he's here in the courtroom.
Oh, I can come out and speak with them. Thank you.
Okay. For Joshua Long.
Thank you.
All right, the gentleman that just joined the Zoom session, can you tell me your name?
Yes, Demetri Lofton.
All right, 1 second, sir.
That's mine, Judge.
All right, Mr. Lofton, your attorney is in a breakout session or talking to another client. I'm going to put you back in the waiting room, and when she's available, I'll bring you back in.
Okay.
What case are you here for?
Shane Pringle.
Ready to proceed, Mr. Pringle, Mr. Brown?
Yeah, sure. I will say, we have a plea, but I did forget to bring the advice of rights for him to sign. I do have to figure him to sign.
Attorney. This is file 26-22694-FH People versus Shane Lee Pringle. We are here today for arraignment in this file, and we are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. McCready.
Dave McCready for the people.
Brian Fry for Shane Pringle.
And sir, you are Shane Lee Pringle?
Yes, sir.
All right. Mr. Fry, does Mr. Pringle wish to have the information read?
We would waive the reading of the information, Your Honor.
And how does Mr. Pringle wish to proceed?
Your Honor, we do have a resolution to this case. My client has signed the advice of rights as well as the plea agreement, as well as myself and the prosecutor have submitted that to the court. My client would plead guilty to count one, police officer resisting, obstructing. Count two would be dismissed, count three would be dismissed, and then my client would also plead guilty to count four, retail fraud, second degree. All habitual offender notices would also be dismissed.
Mr. McCready, is that a complete and accurate statement of the plea agreement?
The plea form that I see also includes a provision that restitution as determined by the court would be paid by the defendant.
Part of the agreement.
Yeah, that's fine, Your Honor. It's a retail fraud, so I think that's appropriate.
All right. Mr. Pringle, would you raise your right hand to the extent you can swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And again, you are Shane Lee Pringle, correct?
Yes, sir.
Mr. Pringle, you've heard the statement of your attorney and the prosecuting attorney to your intention to plead guilty today to count one, assaulting, resisting, obstructing a police officer or first responder.
Yes, sir.
You understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine.
Yes, sir.
Is it also your intention to plead guilty today to second-degree retail fraud?
Yes, sir.
And you understand that the maximum possible penalty for that offense is up to 1 year in jail and a fine that's the greater of $2,000 or 3 times the value of the property it's taken?
Yes, sir.
Are you satisfied with Mr. Fry and the advice that he's given?
Yes, sir.
Neither the prosecutor, defendant, nor anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. McCready?
Yes, that's correct.
Mr. Fry?
That's correct, Your Honor.
Is that also your understanding, Mr. Pringle?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify if you wanted to testify. Do you understand, Mr. Pringle, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right? If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
Yes, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about February 1st, 2026, in Madison Township, Lenawee County, Michigan, that you did commit the offense of assaulting, resisting, or obstructing a police officer or first responder?
Guilty.
And how do you plead to the charge that on or about February 1st, 2026, in Madison Township, Lenawee County, Michigan, that you did commit the offense of sex? Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that the pleas were given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Pringle to plead guilty today?
No, Your Honor.
Mr. Pringle, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes, sir.
Mr. Fry, you want to establish the factual basis?
I can do that, Your Honor. How you doing today, Mr. Pringle? So Shane, on or about February 1st, 2026, were you in Madison Township, County of Lenawee, State of Michigan?
Yes.
And were you at the Walmart there?
Yes, sir.
Okay, and while in the Walmart, did you steal some items?
Yes, sir. I did some stuff in the backpack.
I'm sorry, I'm having a hard time here.
I concealed stuff in a backpack, probably.
Okay, was that items that were there for purchase?
Yes.
Okay, but you didn't pay for those items?
No.
And did you attempt to leave with those items?
Yep.
Okay, and was the value of those items between $200 and $1,000? And you didn't have permission to take those items? After exiting the store, did you encounter some police officers?
Yep.
And was one of those police officers Corporal Forrest Howard?
Yes.
And was he a Lenawee County Sheriff?
So it's yes.
Okay, so you knew that he was a police officer? Is that a yes?
Yes.
Okay, and did you attempt to run away from him?
So that.
Okay. And you knew that he was trying to stop you?
Yes.
And did he tell you to stop?
Yes.
And you ran?
I ran.
Okay.
People are satisfied.
Has the court complied with MCR 6.302 B, C, and D?
Yes.
Yes, Your Honor.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Pringle has had full knowledge of his rights, and he has had competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for September 10th at 8:15 a.m. Mr. Pringle, this is sentencing in a felony case. As a result of that, you have a right to be present in person in the courtroom for the sentencing hearing. If you don't want to be present, we can do it by Zoom, but you would have to waive your right to be present in person. Do you know what? I'm sorry?
I want to be in person.
You want to be in person? Okay, so Mr. McCready, can we have the prosecutor's office do a in-person writ for Mr. Pringle for his sentencing hearing?
And can you tell me again when that was?
That was September 10th at 8:15.
Okay, yes, we'll do.
All right. Is there anything else we need to address with Mr. Pringle's case today?
Not from the people.
Nothing further.
All right, thank you for your time then. We are all set.
Thank you, Your Honor.
Ms. Underwood, are you ready to proceed with Mr. Roll?
Yes, thank you.
Roll, you can come forward and sit at the table here closer to the television. This is file 23-21406-FH and 23-21497-FH. People versus Caleb Emmanuel Roll. We are here today for a hearing on a probation violation in each of those cases, and we're proceeding today partially in person and partially by video conference. Ms. Underwood, can I have you place your appearance?
Rhonda Underwood for Mr. Roll this morning, Your Honor.
And so you are Caleb Emmanuel Roll.
Yes, sir.
Ms. Underwood, where do we stand with Mr. Roll's situation today?
I have reviewed with Mr. Roll the new probation violation request and warrant, Your Honor. I don't believe he's been formally arraigned on that one, but we have reviewed it, and we just want to take the opportunity to get some dates right and make sure where we are on it. I would ask for a not guilty plea to be entered and or continued, and a short adjournment, Your Honor, a couple weeks. I believe Mr. Roll has demonstrated, Your Honor, that he has no intent, he wants to resolve these matters. He has no intention of going anywhere. He's here on bond and with his family.
Okay, I will adjourn this then to August 26th at 8:15 a.m.
Thank you, Your Honor.
Judge, he hasn't been arraigned on the new show cause. I don't know if you, I think you still have to do that.
I don't have a new show cause in the file.
Dated July 30, 26.
See if it's in the computer system. Okay, Mr. Roll, have you received a copy of the most recent request and summons for probation violation?
Yes, sir.
I don't believe he's received a formal copy, Your Honor. Ms. Holly was kind enough to provide me with the copy yesterday, and I did review it on the screen with him.
I sent him copies in the mail. I don't know if he had got that yet.
Yeah, I got the copy.
You got the copies in the mail, okay.
Great.
All right, so the request and summons for probation violation that was entered on July 30th alleges that you violate the terms of your probation by failing to pay restitution, which would be a technical violation, also by failing to report to your probation officer for more than 6 months, which would be absconding. That's a non-technical violation. And also by engaging in new criminal activity, that would also be a non-technical violation. You had previously in file 23-21497-FH pled guilty to 2 counts of breaking and entering a building with intent. The maximum possible, 1 count of breaking and entering a building with intent. Maximum possible penalty for that offense up to 10 years in prison. 1 count of attempted breaking and entering a building with intent. Maximum possible penalty for that is up to 5 years in prison. In file 23-21406-FH, you had pled guilty to again, 1 count of breaking and entering a building with intent. Maximum penalty of 10 years. 1 count of attempted breaking and entering a building with intent. Maximum possible penalty of 5 years. You're obviously already represented by Ms. Underwood on these probation violations, and the court will enter a not guilty plea on those as requested by Ms. Underwood previously. And again, we'll set this for 2 weeks from today. That was April 26th at 8:15 a.m.
I think it was August.
August, I'm sorry, I don't know where 8 came from. August 26th at 8:15 a.m.
And I could use Mr. Rowell showing up to report Tuesday to me.
Okay, so Mr. Rowell, you need to report to Ms. Holly on Tuesday. Any specific time, Ms. Holly?
He should, between 8 and 10.
Time between 8 and 10. Sir. Okay, is there anything else we need to address with Mr. Rowell's case today?
I don't think so.
Okay, thanks, sir. You're all set for today.
All right, thank you, Judge. Have a nice day.
Ms. Underwood, you need to speak to Mr. Rincon.
No, Your Honor.
Mr. Dagger, would you give Ms. Nicholas?
Yes.
All right, this file 26-22688-FH Peel versus Joshua J. Rincon. We are here today for pretrial hearing this case. We are proceeding today by video conference. Can I have the attorney's place there? Appearance on the record. Good
morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Rincon, Your Honor.
And sir, you are Joshua J. Rincon?
Yes, sir.
Okay, Ms. Underwood, where do we stand with Mr. Rincon's case?
I believe Mr. Rincon is going to plead guilty, Your Honor, to 1 count of child support, felony child support. And it will be a release at sentencing to make payments plea, Your Honor.
I don't recall that discussion, Rhonda. He's charged as a HO4. He's going to admit the HO2.
Oh, I thought we were doing it. We were dismissing the habs.
No, I mean, he's paid nothing. I didn't agree to let him out at sentence.
Okay.
There's no sentencing agreement, Judge. He can plead
Okay.
guilty as a HO
Then-
second. I'll drop it from the 4th down to the 2nd. If he has proof of employment, then I would reconsider that. But at this point, I don't see any reason to do that.
Okay, then we're going to need a new date, Your Honor, just to nail down employment.
Okay. I would also say I don't have any information that's in the file yet. I don't know if that means it's not here, but necessarily, but it's not in the file yet. So you
Okay.
need to make sure we have that.
It looks like we sent it July 31st.
It
So-
could well be in the computer system already.
Okay.
Sometimes it takes a while for the paper to catch up. All right, I can adjourn this then to August 26th at 8:50.
Okay, thank you, Your Honor.
Thank
And our
you,
other
Your Honor.
one, our last one with you, Judge, was Lofton, who was in your waiting room, and he's just going to be an adjournment as well.
Ms. Underwood, you do the stipulation in order for adjournment on Mr. Rincon.
I
No
will be
objection.
more than happy to do that.
Thank you, Rhonda. No objection to you signing for me.
Mr. Rincon, you can let the officer with you know that you're done with court for today.
Okay.
This is file 26-22612-FH People versus Demetric Damon Lofton. We're here today for a pretrial conference. Have the attorneys place their appearances on the record.
Good morning again, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Ron Underwood for Mr. Lofton, Your Honor.
And sir, you are Demetric Damon Lofton.
Yes, sir.
Ms. Underwood, where do we stand with Mr. Lofton's case?
Your Honor, Mr. Lofton is making payments. We would ask for a 60-day adjournment to keep those payments coming, Your Honor. I don't believe the Attorney General's office has any objection, and we would be happy to do the stipend order.
I have no objection to that request, Your Honor.
I'm sorry, did you say 60 days?
She did.
Okay. All right, let's set this then for October 7th at 8:15.
Thank you, Your Honor. I think that was the last one that I had with you. Rhonda, I'll see you over with Judge Anzalone.
I will be there just as soon as I can get there.
Okay. Thanks.
Okay, Mr. Dagger, are you ready to proceed with Ms. Nichols? Yes, Nicholas. Okay, Mr. Lofton, you're all set. You can leave the meeting if you want.
Okay, thank you.
All right, Ms. Nicholas, I'm sending you a request to start your video. And, okay, you're unmuted. All right, so let's see. This is file 25-22170-FH, People versus Brenda Lee Nicholas. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
Dave McCready standing in for Phoebe McClure.
Your Honor, Michael Dagger Margosian for Miss Nicholas.
And Miss, you are Brenda Lee Nicholas?
Yes, sir.
Mr. Dagger Margosian, where do we stand with Ms. Nicholas's case today?
Your Honor, we are still on track for trial. We have previously gotten dates from the court for final pretrial as well as jury trial, both being in December. That is our intention.
Okay. Mr. McCready, is there anything that needs to be addressed from the people's side?
I don't believe so.
All right. We do have a final pretrial conference set for December 2nd at 8:15 with trial starting on December 8th. So Ms. Nicholas, your next date is December 2nd at 8:15 a.m. You can attend that one by Zoom and log in using all the same Zoom information you used to log in today.
Yes, sir.
All right. If there's nothing else, we're all set on this case.
Good.
Ms. Nicholas, you can go ahead and log out.
Okay, thank you.
Oh, it's still on the document. Okay. I'm sorry. All right, Ms. Frank, see, I guess we could get started on that case anyway. Okay, this is file 23-21418-FH, People versus Carly Lynn Frank. We are here today for arraignment on 3 warrants related to, one related to an alleged violation of probation and 2 related to alleged violation of bond conditions. We are proceeding today by video conference. Miss, you are Carly Lynn Frank?
Yes, Your Honor.
Ms. Frank, have you received copies of each of the 3 warrants?
I believe so when I got to the jail.
Okay, so the warrant that was signed on March 25th, 2026 alleges that you left Dawn Farms early and failed to return to the jail, having not completed the Dawn Farms program. That would be considered a contempt of court for violating bond conditions. The maximum possible penalty for the contempt of court would be up to 93 days in jail or $7,500 in fines.
Your Honor, I did
Okay.
go to.
Yeah, you need to not say anything right now.
Sorry.
I've got to say some stuff to make sure you know what your rights are before you say anything at all.
Okay, sorry.
The warrant that was entered on May 28th, 2026 alleges that you failed to appear at sentencing, at the sentencing hearing that occurred on May 28th, 2026. That would also be considered a contempt of court with a maximum possible penalty of up to 93 days in jail or $7,500 in fines. The warrant that was entered on April 13th, 2026 alleges a probation violation in that you were ordered to complete residential treatment if you were released, and that you left treatment on March 23rd, 2026. Also, that you failed to report to your probation officer within 24 hours of leaving the residential treatment. You had, in this case, pled guilty to one count of obtaining, possessing, or transferring with intent to commit identity theft, personally identifying information. The maximum possible penalty for that offense is up to 5 years in prison and or a $25,000 fine. You also pled to one count of identity theft, and the maximum possible penalty for that offense is up to 5 years in prison and or a $25,000 fine. You are entitled to be represented by an attorney at this hearing today and at any other hearings that we have regarding this matter. If you can't afford an attorney, you can tell me that and I'll appoint one for you from the public defender's office. Do you understand that?
Yes, Your Honor.
Would you like to be represented by an attorney today?
Yes, Your Honor.
Do you have the ability to pay for your own attorney?
No.
All right, I will appoint the public defender's office to represent you. I don't have a public defender right now, so I'm going to put your device back in the waiting room, and as soon as I get a public defender, I'll have you speak to them.
Okay, thank you, Your Honor.
This is file 24-21902-FH People versus Russell Micah Monir. We are here today for a hearing on a probation violation in this case, and we are proceeding today by video conference. The courtroom is also open to the public. The record should reflect that this matter was set for hearing this morning at 8:15 a.m. It is now 10:13 a.m. Mr. Monir is not present here in the courtroom, and he is not logged into the Zoom session. He has not been present at any point this morning, either in person or by Zoom. Based on his failure to appear, I am going to issue a bench warrant for his arrest, and I will set bond on that bench warrant in the amount of $10,000 cash or surety.
Thank you, Judge.
Thank you.
I think that's all I have for you today.
Okay, thank you.